Welcome to the Fresh Start webinar series with Mike Wallace. Today we are going to talk about foreclosures. I'm very glad that you're with us, and I know that you are going to get great information from Mike as we did in our other videos, so let's get started. Mike, welcome to the Fresh Start video series.
Thank you, Jordan. I appreciate you hosting this webinar. It is very important information. After all, it's dealing with someone's home. So probably from a financial standpoint, there's probably nothing more important than to talk about foreclosures.
Right. Well, I want to encourage you as you're listening to this video, as we have with the other ones, that Mike is available to answer any questions that you may have, and also his 800 number is on the screen. It's 1-800-867-1583. He is available to do a free consultation. So once again, if you have a question during the webinar, jot those questions down, and then following the webinar, please give him a call to schedule time with Mike. So Mike, what is the foreclosure procedure in the state of Texas?
Well, Jordan, foreclosure on a primary residence in the state of Texas begins with a notice of intent to accelerate that's sent by the mortgage company to the homeowner. So a debtor who's in default on a mortgage must be given written notice by certified mail that they're behind on their mortgage payments. This is the notice of intent to accelerate. That written notice must be given to the debtor at least 20 days before the note is accelerated, and gives them an opportunity to cure the default. So if the debtor is behind 3 payments on their mortgage, then the debtor must pay enough to catch 3 payments up, and in addition must pay any additional payments that come due during the cure period.
Okay, so what happens if the default is not cured during the notice period?
If the default's not cured during that notice period, then the mortgage note is accelerated, and the principal balance in its entirety that's owed on the residence is deemed due. So once a note's accelerated, then generally there's no solution for the homeowner wishing to save the residence from the foreclosure except a Chapter 13 bankruptcy filing, because after all, again, the entire balance has become due. One exception to that would be if the mortgage company is willing to reinstate the note under certain conditions. But debtors should never assume that a mortgage company will negotiate once a mortgage note, though, has been accelerated. It's very unlikely to happen for a mortgage company to agree to reinstate a note.
So what is the next process once a mortgage has been accelerated? The next step that someone should take?
Yeah, what happens, the foreclosure process from the mortgage company standpoint is a 2-step process. So once the note has been accelerated, then the mortgage company is statutorily obligated to provide at least 21 days written notice by certified mail, once again, to the debtor that the property will be sold at a foreclosure sale on the first Tuesday of the month. All foreclosure sales in the state of Texas are always held the first Tuesday of the month. So this notice is, in addition to being sent by certified mail, is also posted in the public notice section of the courthouse for the county in which the property is located. It's just posted with all of the other public notices.
So what if the debtor does not sign for the certified mail when it comes?
Well, the mortgage company is not obligated to make sure that the debtor receives a notice of default or a notice of foreclosure sale. In fact, the mortgage company has satisfied its statutory obligations once the notice is deposited into the United States mail, postage prepaid, addressed to the debtor at the last known address for the debtor. So the mortgage company can satisfy its statutory notice requirements by having an affidavit sworn to the effect that the notice was given. It is never a good idea to not sign for certified mail, because the statutory notice period begins to run upon mailing, and the debtor may be totally in the dark about the fact that the foreclosure process has begun. So they may be sitting there for a period of time, and the mortgage company has satisfied its obligation once they've deposited the notice in the mail, and so the clock is running. So it's very, very important to make sure that you sign for certified mail when you get a notice of it.
Right. I guess that goes right into our next question is what should I do if I receive a notice of default on my residence?
Well, if you're not in a position to cure the default upon receipt of the notice, then I recommend that you contact an experienced bankruptcy attorney to discuss your individual situation. It's always best to act promptly. If you believe you're in my area and I can help you, then certainly, I think as you mentioned earlier, Jordan, I would recommend that person give me a call on my toll-free phone number and offer free consultation. There's no obligation, and we'll discuss your situation.
Right. And Mike, and I know that we will touch upon this at the end, but just for reassurance, when someone calls your office, how do they get you? Do they get an answering machine? What's that experience going to be like?
Jordan, I've been doing this a long time, and over the years I've kind of evolved, but I'm at a point where I basically answer my own phone. So they're going to get to talk to me if, for whatever reason, I'm busy, I'm tied up at that moment when they call me, then certainly I would just ask that they leave me a message, and then I will call them back. A legal assistant won't call them back. I will be the one to call them back to talk about their individual situation.
Excellent. Now, Mike, what happens to the process if I'm working with a mortgage company on a modification?
Well, I can't tell you, I've had so many people that have contacted me over the years who told me that they're working on a modification of their mortgage loan and they all of a sudden received a notice of default. Mortgage companies are notorious for stringing debtors along in a modification process and then all of a sudden advising them that they don't qualify for the modification. So don't rely on a modification to stop a foreclosure. You would always be well served to contact me and let me know the status of your mortgage payments and to discuss your options. I've seen time after time a debtor contact me related to their mortgage payments and tell me that they were on the eve of a foreclosure and the mortgage company all of a sudden said, well, you don't qualify for a modification.
Oh, that's pretty terrible. So, Mike, how does a Chapter 13 bankruptcy stop a foreclosure?
Well, a bankruptcy filing creates a stay as to any pending foreclosure. So, in other words, once a bankruptcy is filed, the mortgage company cannot take any further action with respect to a foreclosure without permission from the bankruptcy court. So the amount that a debtor is in default at that point, what we call the arrearage amount, is provided for in a plan of reorganization of the debtor's debt. This arrearage amount is paid over the course of the Chapter 13 plan of reorganization, which is no shorter than 36 months and no longer than 60 months. So as long as the debtor is making their payments as required by the Chapter 13 plan, and they are staying current on their mortgage payments that come due after the filing of the bankruptcy case, then there's no basis for the mortgage company to be allowed to lift the stay and proceed with foreclosure. So Chapter 13 is the solution to a situation where a mortgage has been accelerated, or even if it hasn't been accelerated yet, and the payments are significantly delinquent, and the debtor does not have the ability to catch those payments up except over an extended period of time, then certainly they're a Chapter 13 candidate and they should give me a call.
So that was my next question. What is the next action to take, and how quickly should that action be taken?
Once a debtor gets notice that there's a pending foreclosure, it's very, very important for them to pick up the telephone, give me a call, and let's start gathering the information for their individual situation and propose a plan of reorganization that will get them on track, that will allow them to stay in their home and ultimately to be financially successful. That's what this is ultimately all about, Jordan, is allowing the debtor an opportunity to get a fresh start and to get their finances squared away such that they save their home and they get on the right track with respect to handling their finances when they come to see me. Even Jordan, if ultimately they don't file a bankruptcy, like I said, I've been doing this from a bankruptcy standpoint about 10 years. I've been practicing law 20-something years. Last 10 I've devoted to bankruptcy law. So there's a lot of things that I can share with people who are in financial crisis. I serve a large area. I believe on the screen right now you will see some of the cities within that area, and of course there's lots of points in between. If you're concerned that maybe you're not in that location area, then just pick up the phone, give me a call. If you're not in an area where I can help you, then I will make sure that I get you to somebody who can.
Excellent. Well, Mike, thank you so much for this informative webinar, and we are going to close there, but I want to invite our listeners to visit the website to check out the blogs. Mike writes a lot about various financial situations that you may find yourself in, so that when you give him a call after reading one of those articles, you'll have a framework about options and how you work and just a little more information. So Mike, thank you for being willing to share, to help, and to really meet people at their point of need in this very sometimes difficult to navigate situation.
Jordan, I appreciate you hosting today. Thank you very much.
Thank you.